Welcome to the Consumer Finance Podcast. I'm Chris Willis, the co-leader of Troutman Pepper's Consumer Financial Services regulatory practice. And today we're going to be talking about a recent set of frequently asked questions that the CFPB released related to its interpretive rule classifying buy now, pay later products as credit cards. But before we jump into that topic, let me remind you to visit and subscribe to our blogs, TroutmanPepperFinancialServices.com and ConsumerFinancialServicesLawMonitor.com. And don't forget to listen to our other podcasts. We have the FCRA Focus, all about credit reporting, the Crypto Exchange, all about crypto. We have our privacy and data security podcast called Unauthorized Access, our payments-related podcast called Payments Pros, and our newest podcast, Moving the Metal, which is all about auto finance. All those podcasts are available on all popular podcast platforms. And speaking of those platforms, if you like this podcast, let us know. Leave us a review on your platform of choice and let us know how we're doing. And if you enjoy reading our blogs and listening to our podcasts, our mobile app is a great way to do it. Just search for Troutman Pepper in your app store, whether you have iOS or Android, download it and give it a try. Now, as I said, today we're going to be talking about the CFPB's Buy Now, Pay Later interpretive rule, which in my mind ranks as probably at least one of the top 5 most controversial things that the CFPB has done this year, classifying Buy Now, Pay Later accounts as credit cards under Regulation Z for various purposes, including things like periodic statements and Fair Credit Billing Act disputes. And the fury that sort of came from the reading of that interpretive rule has now been followed by a set of frequently asked questions that the CFPB has released. And so I think it's fair to say that the CFPB has not done anything to quell the controversy, but rather has probably added to it through these frequently asked questions. And joining me to talk about that subject today are two of my partners who are very, very well versed in this subject. First, we have my partner, Mark Furletti, who's the other co-leader of our Consumer Financial Services regulatory practice, and our other partner, Jason Cover, who also is an expert on truth in lending, credit cards, and buy now, pay later. So Mark, Jason, thanks again for being on the podcast.
Thanks, Chris.
Thank you, Chris.
Okay, so Jason, let me start with you. So we know we had this interpretive rule earlier this year where the CFPB basically took the position that if a buy now, pay later account is accessed through like a username and a password, that it is a credit card for certain purposes under Reg Z. They've now released these frequently asked questions, I guess designed to educate the industry more about what they meant with the interpretive rule. What does the frequently asked questions cover?
Thanks, Chris. I guess, one of the burning questions when the original BNPL card rules were released is, well, what the heck is buy now, pay later? And I think, unfortunately, this FAQ doesn't really provide much assistance in that regard. So they say buy now, pay later products are typically, so we don't even know if we can rely on this, but they're typically loans to consumers that are structured as installment loans and made to consumers for the purchase of personal, family, or household goods and services. So anytime you get a loan for anything that's goods or services on a consumer basis may be buy now, pay later, which is a pretty broad view. I mean, an auto loan could be covered here, right? So to make matters worse, they kind of elaborate further. They may or may not have interest or other finance charges. They may include fees. They may be 4 payments or less. They may be less than that or more than that. Who really knows? And then to make this guidance even sort of less worthwhile, the FAQ specifically applies only one certain type of buy now, pay later product. And that's what we typically call the traditional pay in 4 model that doesn't have a finance charge and is due in 4 payments. So that's kind of all we have to go on for the time being.
Okay, so far on the sort of strike ball count, we've got the CFPB like 0 for 1 in terms of actually answering a question is what I hear you say, right?
Well, I guess it depends on whose point of view you're giving balls and strikes in. I think it might be very carefully intended to be as broad as possible, but maybe that's just a cynical view on my part, Chris.
Well, we enjoy cynicism here on the Consumer Finance Podcast, so I welcome it. So Jason, the other thing that was kind of the linchpin of the interpretive rule when it was released is that the buy now, pay later product was accessed through a digital user account. And that was the thing that made it a credit card, I think, in the CFPB's mind in the interpretive rule. So does the FAQ provide any clarity to the definition of what constitutes this digital user account that supposedly is the linchpin of making it a credit card?
You're absolutely right, Chris. The BNPL rule kind of had 2 components. We needed, or maybe in theory, we needed something to be BNPL. And then you had to have this digital user account. the original rule never really defined it. It wasn't, if you look up the definitions of Reg Z, most of them are, I can read that and tell you for the most part whether you're in or out of a definition. They're pretty tight and have multiple components. And if you're missing a component, then you don't meet that definition. In contrast, the BNPL card rule sort of loosely elaborated on what the digital user account may or may not be. And unfortunately, the FAQ is sort of the same thing again. Generally, they say that it's access using a consumer's digital user account. And this is a secure personal profile that BNPL provider activates for a consumer, enabling the consumer to access and use BNPL credit. So this is essentially kind of the same thing that they were saying before. And it begs the question of how broad is this? Do we need a certain type of digital user account? Or again, sort of like going to that extreme, like is an auto loan where, maybe I go to the same car dealer every year and they keep my account information and I don't have to complete the whole application for credit again. It's sort of a broad swath here. And it's very, very difficult, I think, for folks that may be in the BNPL industry to know whether they're in or out. I'm not sure that this FAQ really helps us much.
Okay, so I guess that means our cynicism level is only rising further as a result of that second answer from you, Jason.
I think that's right, Chris.
By the way, I just would point out as a historical matter that one of the criticisms of the Truth in Lending Act during its first roughly decade of existence was that it was too broad and too ambiguous about what was covered and what the disclosure obligations were. And sort of the major thrust, as I recall it, of the Truth in Lending Simplification Act was to make it much more defined, of like you knew whether you were in or out and you knew what disclosures you were supposed to give. And it feels like that maybe this is calling out for another simplification process as we had in 1980. But we'll see if you get that.
Or Chris, I suppose we could just read Reg Z as it is and not have random interpretive guidance.
Well, that would be even more helpful, I think. So, Mark, let me switch over to you. Another one of the things that I remember being very puzzled about after reading the interpretive rule was which parts of the open-end credit provisions in Reg Z are supposed to be applicable to a buy now, pay later, quote, credit card. Because the CFPB, as I recall, mentioned periodic statements and Fair Credit Billing Act disputes, but just as examples and weren't very exhaustive about what was supposed to apply and what's not. Did they answer that question in the FAQ?
So, Chris, they provide an answer, but it's an answer that's internally inconsistent and in conflict with where the remaining parts of the guidance actually conflict with it. So question 3 is a question about the extent to which what exact provisions of Reg Z might apply. And so in this regard, the CFPB says, well, the ones that apply to card issuers, they certainly apply because a BNPL provider is a card issuer for these purposes. But then they say that provisions that target open-end specifically, for example, open-end consumer credit plans, or that apply to credit card accounts under an open-end, not home-secured consumer credit plan, what I call Card Act credit card provisions only, to the extent they apply exclusively to those things, they say they don't apply. But then they contradict themselves because later, if you go to page 11 of the guidance, they then go on to say that the periodic statement requirement, that a periodic statement be mailed or delivered at least 14 calendar days prior to the end of the date on which the periodic statement must be provided, which is in 1026.5 B2 Romanet 2B, that requirement is prefaced by the exact thing they say that when something is prefaced by, it doesn't apply, i.e. the open-end consumer credit plans. So this makes no sense, right? They're saying, oh, any requirement that applies exclusively to an open-end consumer credit plan doesn't apply. But then later they're telling us that one of the requirements that applies in that same way, such that it should be excluded, it's brought in. So it makes no sense. The second problem with all this is that it appears they are deviating significantly from the plain language of the Truth in Lending Act itself. So the Truth in Lending Act itself has a definition of creditor. And a lot of people, practitioners, you don't often look to the Truth in Lending Act because Reg Z is normally comprehensive in how it treats things. But in this case, I think it's critical to look at the statute because it sheds a lot of light on some of the terms, their meaning in the regulation. And so if you look at that definition of creditor, there's actually Congress right, who should trump the CFPB,
Supposedly.
they tell us exactly what provisions apply to a product like this. And they're talking specifically about someone who is a card issuer, but the credit they issue is not payable by agreement in more than 4, or where there's not a finance charge. So that's exactly what we're talking about here, particularly given that the rule singles out the kind of traditional BNPL no fee, then they are this kind of creditor. And the Congress says that the Bureau by regulation can apply certain requirements, and they specify the requirements, and they're limited. There's only 9 of them. The CFPB is applying requirements beyond those that are set forth in 1602G, in 15 USC 1602G, the definition of creditor in the Truth in Lending Act. So this seems very ripe for kind of in the post-Chevron world, a challenge, because they are totally disregarding the statute. I mean, in addition to disregarding their own guidance, which they give on page 6, they're also kind of disregarding what the statute says. And the statute applies a rather limited or narrow set of requirements to these kinds of creditors. And so bottom line, what they have here, I think, is somewhat nonsensical. They said a bunch of stuff applies. They say some things don't, but then the principles that they're applying, they're not following themselves.
Mark, it sounds like from the tone of your comments that you're thinking about making a little career change and coming over and doing some litigation.
Yes, I would welcome the opportunity to be involved in litigation over this, because I feel pretty strongly that they're on thin ice.
Yeah. So we've talked so far about some of the sort of burning questions that we all had when we read the interpretive rule when it first came out. So we sort of, I guess, hoped and expected there'd be answers to those, although I don't know that we got the answers that we wanted. But Jason, were there any unexpected things that showed up in the frequently asked questions?
Yeah, I guess, Chris, I think the FAQ in some ways is more expansive than the original BNPL card rules. For example, the card rules say that lenders that issue digital user accounts to access BNPL credit are generally not subject to credit card regulations appearing in subpart G. Now, they snuck this little footnote in that said, however, 12 CFR 102660, this is the card application solicitation disclosures in subpart G may apply, but they didn't tell us what types of BNPL card issuers might be subject to subpart G or 102660 in particular. They've reinterpreted or expanded on this little footnote, I suppose, to make traditional pay in for no finance charge BNPL providers charge card providers under Reg Z that now must comply with 102660 and presumably need to cover anything else that might apply to a charge card under Reg Z as well. So I kind of saw that footnote before and wondered what they meant, but it definitely, I think, caught us a bit off guard to see that these charge card provisions were now being asserted as well.
If I could just add to that, Chris, I mean, what they've done here is they've promulgated a second substantive rule, right? So like we had the first thing that they promulgated, which is a substantive rule that they was not promulgated, I think, in accordance with the Administrative Procedures Act, and should have been probably. And then now they're doing yet another expansion they're saying something different than they said before, and they are subjecting a product to an additional set of requirements that they didn't say in the first. They made no mention of this in the first interpretation that they put out. So I would give this as it's like a substantive change in the law to, the kind of step one was these things are credit cards. And now step two is they're also charge cards, even though we did not say that the first time around. So we've gotten like worse to the extent that we were looking for like some guidance that maybe cabined in or narrowed down and made more clear what requirements apply. We've actually gotten the opposite of that. They're making new rules. And again, no administrative procedure. There's no comment. It's just like, here it is. This is our interpretation. Seems totally in disregard of kind of administrative procedures.
Okay, so Mark, we had talked about periodic statements, and that was one of the things that was in the original interpretive rule. I know there were a lot of questions on the industry side about how a buy now, pay later provider is supposed to provide the information that's required by Reg Z and periodic statements. Did the frequently asked questions help clarify that question at all?
So Chris, I guess this is maybe the single thing in here that isn't totally bad news and isn't kind of possibly introducing new and novel requirements. The CFPB suggests in here that the periodic statements could be done 2 ways. And I think the prior guidance suggested there might have only been one. So this is good. It's giving some flexibility to BNPL providers. Specifically, the way their original guidance was written, it looked like you had to create a consolidated statement of all BNPL transactions. So imagine I have a calendar month statement period and I make 3 transactions, 3 BNPL transactions. The prior guidance suggested, I think, that you might have to create a single statement for that month that reflects all 3 transactions and then reflects the payments due on all 3 of those transactions and kind of provides information on like the sum of those transactions. So that would have been kind of onerous, or could be depending on the systems that the BNPL providers have in place. They have said in this guidance that a BNPL provider can treat each BNPL loan as a separate credit card account. That is, you can pretend like each one is a standalone extension of credit for the purpose of the statement. Just as an aside, the way they worded that, I would have just said that you could have statements that reflect one transaction, but they say that each loan is a separate credit card account. I don't know why they'd want to say that someone could have like 200 credit card accounts over the course of a year through doing a couple hundred purchases, but it's kind of a very odd way of saying it. But in any event, the bottom line is, at least I think there's a little bit of flexibility here, and we can have kind of transaction level statements, or we can have digital user account level statements. Either seem to be fine.
By the way, it also seems to me, just from listening to you, Mark, that this concept that each transaction is a separate credit card or separate credit card account doesn't square very well with the rationale for it being a credit card in the first place, that the digital user account is what makes it a credit card.
I agree. And then, yeah, that could open a whole can of worms. I don't think that's what they're saying here, but I agree with you. It's just a very odd way of answering this question.
Well, as you can see, I'm trying to angle to help you out with the litigation when it comes.
Yeah, there you go.
Well, Mark, Jason, do you have any sort of last thoughts about the FAQ or advice about this for BNPL providers?
Chris, I think our experience is clients are sort of starting to make decisions on how to comply based on their business practices and their risk tolerance. But I would say this industry, BNPL in particular, I think has really jumped through a lot of hoops and bent over backwards in an attempt to comply, right? There hasn't been litigation. Most of the industry statements have been pretty positive. And the only ask has been, hey, could you help clarify what some of these things mean or what exactly we need to do? And the answer, I think, has generally been, well, everything has to be complied with, right? Whether it says open-end credit or not, or if it's a charge card or not, like everything is BNPL and everything in Reg Z applies, so on and so forth. And then sometimes, like the charge card thing, additional items are tacked on. This is just a long way of saying, I think at this point, attempts to get clarification, either formally or informally, may not be entirely helpful because the response aren't helpful. And if anything, just sort of broaden the scope and the problems that we already have.
And there it is, the final crowning example of cynicism from you, Jason. Thank you. Mark, what do you have to say to close?
I mean, I just kind of reiterate what I said before. I think if someone were to dig into all of this and spend some time, the challenge to it would write itself here, where you have just kind of a promulgation of a substantive rule that's inconsistent with the current rule and inconsistent with the Truth in Lending Act statute itself. Just so many problems that I'd like to see someone challenge it, because I think otherwise there's going to be a fair amount of confusion and it won't be clear kind of what is a violation or what is not a violation in the eyes of the CFPB. And so I think at least they should be forced to go to kind of be more disciplined and more clear about what they're doing and kind of follow the law. So it'd be nice to see something in that regard.
Well, Mark, I would definitely say that I agree with that sentiment, because I view the CFPB's interpretive rule and this set of FAQs as being, a very well outside their authority set of actions that are very much ripe for a challenge. And we'll just have to wait and see if somebody from the industry decides to do that, either now or in response to some sort of enforcement action by the CFPB, which might also trigger it. But for now, let me just thank both of you for being on the podcast and thank our audience for tuning in today. Don't forget to visit and subscribe to our blogs, TroutmanPepperFinancialServices.com and ConsumerFinancialServicesLawMonitor.com. And while you're at it, why not visit us on the web at Troutman.com and add yourself to our Consumer Financial Services email list. That way we can send you copies of our alerts and advisories and invitations to the industry-only webinars that we put on from time to time. And as I said at the top of the show, don't forget to check out our handy mobile app. Whether you have iOS or Android, just go into your app store and search for Troutman Pepper, download it, and give it a try. And of course, stay tuned for a great new episode of this podcast every Thursday afternoon. Thank you all for listening.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.